Hi, in this video we're going to give you a brief summary of what probate is and what type of probates exist in the state of Florida. So basically, probate is the process under which the judge supervises the distribution of your assets when you die. And there are two situations when you can end up in probate. Number one, you don't have a will, so that basically the law gives you a will, basically staying in the probate rules of the Florida Probate Code. And when you have a will, so get that clear, because a lot of people ask me or think that because they have a will, they don't go to probate. No, will is your way to probate. So it's your ticket to probate. So when you have a will, you will go to probate. So again, is the process under which the distribution of your assets is supervised by a judge. So that's why the probate is done through the courts. And the judge basically, if you have a will, blesses the will and say, yeah, this will is valid, and therefore we're gonna go ahead with the probate process. So there are a few steps that we need to do in the probate process. And again, these are more or less the steps. It's a summary. There are many moving parts within each step, but basically this is gonna give you an idea of what probate is. So everything starts with, again, you dying, you having a will or not having a will, and you owning property individually. Again, property that you own jointly or property that you own with a contract in a bank or an institution doesn't go to probate. So you have to own property individually. So everything starts with a petition for administration, where you hire an attorney or someone in your family hire an attorney and ask the judge to start the probate process. One of the first things that you do here is you obtain the appointment of a personal representative. Personal representative is the same as the executor in other states. That's the person responsible for conducting the administration of the probate. So what is the administration of the probate? So basically, first, what you do is you identify who are the creditors of the estate. So who the decedent owes money to who, and you need to communicate with that person. Hey, this person died, and do you have any claim? Please submit your claim to the court so we can see if we can pay you. Within that, so you have to run publications. So you have to do what is called look for creditors. And one of the ways to look for them is by running publications in the county when the person died. The other way is by communicating, so you know who that person died. Who is the creditor? Let's say is a credit card company or a bank or someone, and then you contact that person and say, look, so-and-so died, you know, tell me how much we owe you. So that's what you do. So you also, during this period of time, you identify what assets are part of the probate estate. So let's say you say, I own a property, a home, a bank account, life insurance, whatever, everything in my name. So that's what it is. What is the inventory? So you submit an inventory to the judge and you tell the judge, hey judge, I have these properties and these are the value of the properties and this is what we were able to collect. So once you do the inventory, then you do an accounting. So in other words, you tell the judge, hey judge, I pay this, I pay that, this one I objected, so on and so forth, and we have this. So now out of this debt, we have a balance of, let's say, $1 million in assets, and we have two beneficiaries, and these are the beneficiaries, the spouse and the kids. Let's say, for example. So all that process, that probate process, takes about a year. Okay, so in a year you're supposed to finish the probate. If you can't finish in 1 year, then you need to ask the judge for an extension, or you need to give reasons. Let's say you owe estate taxes, and therefore your probate process can take longer. But in normal circumstances, for a non-taxable estate, the time frame is 1 year. Now, That's for what is called formal administration. Formal administration is when you just die, or you own the value of the estate is more than $75,000. If you have less than 75 or less, then you do what is called a summary administration. A summary administration, so it's less than $75,000 in assets, or you've been dead for more than 2 years. So in those two circumstances, you can do what is called a summary administration. In a summary administration, like the name says, is a way more fast, efficient process. You don't have to appoint a personal representative, so you just file a petition saying this person dies, the estate is worth less than $75,000, or this person has been dead for more than 2 years, there is no debts, so on and so forth. And you file the petition, and basically the judge gives you an order. Now, in some counties, like Miami-Dade, they ask you to do the publication. So a summary administration can take 90 days or more. In other counties, like in Broward or Palm Beach, they don't ask you for publication. So you can do a summary administration in less than 90 days. You can basically finish a summary administration in, let's say, 60 days, 30 days. It depends on how fast the judge can hear your case. So basically, that's what is probate. Again, the basic key points. Number one, probate. A will takes you to probate. That's number one. Number two, probate only applies to assets that you own individually. That's when you go to probate. That's pretty much what we need to know about probate at this point. We're going to give you more details later about certain stages of this process, but this is what you need to understand about probate today. Thank you very much.